The meeting of the Criminal Law Subcommittee of the Courts will come to order. Clerk, please open the roll. Members, please cast your attendance on the board. We have 8 members present. Thank you. And please close the roll. As an administrative action, should we pass HB 2088 Shin, it will be re-referred to appropriations. I don't at this time have any requests from patrons, but as chair, just to explain to our people online and in the room, although we have the docket before us, I really do not want to take up the discovery bills at the top of the docket until we have Thomas in the room, along with Davis and hopefully also Keys Gamara. So therefore, do we have Leftwich in the room? He's on civil, so okay. We don't have Hayes in the room. Shin. Coulson, can you present your bill at this time? Coulson's bill is HB 2242 and has to do with post-release supervision.
Delegate Early and Delegate Cherry are here.
Okay.
Davis.
Yeah, Davis, I want to wait with Thomas. Yeah.
Hello, Madam Chair. I have a substitute to introduce, and I'd be happy to talk through those changes that I'm asking for, if I can. So the substitute makes some quick changes, and then I'll talk about the reason why. It is striking any change to Code Section 53.1-162. That code section dictates post-release supervision, and it's not an issue that is addressed by my bill, so it strikes that. On line 27, it strikes a mention of PB-15s and major violation reports, and instead inserts the language all relevant case numbers. The reason for that is that it's not necessary to restate. A PB-15 is actually just a term people use. It's not in code section, so it's not necessary to state that it's included in A. And then on line 29, it inserts the word promptly before the word issue. Issue a capias or bench warrant. And with those changes, I'm happy to talk about the bill. This bill is addressing a problem that was brought up at VCJC. It is not a VCJC bill, but in that room, which had defense lawyers, prosecutors, judges, there was consensus that there was an issue when PB-15s are introduced, when someone is incarcerated under a PB-15, that they can sort of fall through the cracks. So if they go to their parole or probation, they go to the probation officer, and there is a violation that warrants their immediate incarceration under current code section, that parole officer can do the PB-15, and that person will go to jail. But what is not necessarily kicked off is a capias, a court case number, and there were situations where people brought up that they arrived at a jail to help out their client, and they saw someone else there who was like, "Oh, are you here for me?" Nobody knew that the person was in jail. These people, if the paperwork is lost or if someone just delays, these people can sit in jail for, I've heard, up to weeks. It has occurred where they've sat for weeks without people realizing it. So my colleague Will Davis had a bill that addressed this as well. I worked with stakeholders all summer, and these changes encompass trying to bring peace in the valley, which hopefully everyone behind me nods when I say that we got there. And it was through a lot of hard work. And so this makes it so that now when a PB-15 is issued, there will be some sort of process to make sure that the court is aware a court case number is issued, and we can get a speedy trial or speedy proceeding in court.
Are there any questions of the patron? Counsel, anything to add to the explanation?
No, Madam Chair, we were part of the discussion, so we've done a lot of
fixing prior to today.
All right. Then I believe we're ready to hear from the audience, from the public. All those who wishing to speak in favor of HB 2242, please come forward so I can see how many we have. Please limit your total remarks to, I'm going to say 6 minutes. Go ahead.
Madam Chair, members of the subcommittee, Rob Hogenclass for Justice Forward Virginia. We really appreciate the delegate getting all these stakeholders together. It's been a lot of work, as she said, but this is a good bill. I've heard up to 2 months. There are parts of the state where courts, probation officers use PB-15s up to 90% of the time when they're filing a probation violation, and then the court just doesn't have a process to start. So this makes sure that courts will have a process. That process will get started, and people will get in front of a judge. We have another probation reform on the books where you can only get up to 14 days for certain violations of probation. So we have people sitting in jail longer than their violation would actually incur for time. So it's a good bill. We support it. Thank you.
Thank you.
Good afternoon, Madam Chair. My name is Nathan Green. I'm the Commonwealth Attorney for the City of Williamsburg and James City County. Unfortunately, I'm here speaking just on my own personal behalf because of the delegates' patience. This was worked on all the way up to today. And so, but speaking as a prosecutor, I appreciate all the work that Delegate Carlson put into it. I think this is a bill that prosecutors would support. It's just one that up until the last minute, we didn't get a chance to see, but the concept is something we have supported all along. And so we thank the delegate for bringing it.
Madam Chair, Committee, Fatima Mowahed with the Humanization Project. We thank the delegate for bringing this bill. This legislation establishes a clear and streamlined process and ensures that the necessary legal proceedings are initiated promptly. It reduces the amount of collateral consequences like losing jobs and becoming unhoused, being separated from your family, or even losing your children. It creates immediate action, and we hope you support the bill. Thank you.
Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Sincere Allah. I am a state organizer for Reform Alliance, and for reasons already stated, we support the bill.
Thank you.
Good afternoon, Madam Chair, members of the committee. Kenneth Hunter, criminal justice reform organizer for the Virginia Interfaith Center for Public Policy, and we support the bill for the reasons previously stated.
Thank you.
Good afternoon, Chair Watts and Committee. Sheba Williams with No Left Turns. I'm also the Reentry Council Chair for District 32. We support the bill for the reasons stated, and just want to make sure that people know that the pretrial support that we provide lends unnecessary spending for people who are held without any type of hearing just because of the process. I didn't think it would have to come to legislation because it seemed like common sense, but people are not being notified that people are sitting in jails, and then the judges are using the authority to say, oh, if we issue multiple violations, then they sit for longer than the period that was addressed in HB 2038. So we support the bill. Thank you.
Thank you. Is there anyone in the room wishing to speak against 2252? And online, that's 2242. 2242. We also have online speaking for Seth Weston. Seth?
Yes, ma'am. Thank you very much. I'm a private attorney in Roanoke, Virginia. I support the bill as it's written. I myself has had many cases where a probationer has sat in jail unable to even have a bond hearing because the PB-15 is not a warrant that the circuit court clerks recognize and is able to put a case to. It has to be sent to the clerk's office to become a warrant, to become a case. And on an outlier case, an egregious case, I had a man sitting in a regional jail for almost 4 months. The warrant had been issued, hadn't been served. So it's still going to go back to the clerk's office as a case. So something clearly needs to be done here so these things stop happening. My only critique would be it doesn't affix responsibility or a repercussion if the probation officer doesn't notify the court or a KPS or a warrant is not served in a timely manner, that person's still sitting in jail. But it's certainly better than what we have going on now because at least the probation officer is supposed to notify the court it's been issued and that doesn't happen a lot of the times.
Thank you. Thank you. The next one online, Dwayne Barron.
Yes, good afternoon, Madam Chair, Committee. I'm Dwayne Barron with Justice for Virginia as well. I'd echo what Seth just said. We have many clients who get stuck in jail for days without us being able to represent them. And that's really one of the big problems we're trying to fix here with the bill. And I really appreciate Delegate Carlson and the work she's done on this bill. So we support the bill, and thank you very much.
Thank you. Delegate Carlson, I think you have won the room. Not sure about the panel, but.
Thank you, Chair Watts.
Final word.
No final word other than a very sincere thank you to everyone who really put in good faith efforts to make us arrive at a solution.
Do we have any questions or comments? I see no one on the request to speak. It's been moved and that we report the substitute. Was that as amended? I thought there were additional amendments. No, just as the substitute. All right. It has been. Any further discussion? Clerk, please open the roll. Members, cast your vote. HB 2242 is reported by a vote of 8-0 with substitute. Okay. So again, I'm trying to group bills. Please help me, Delegate Williams. So I see separate bills.
Delegate Hayes is here.
Yeah, let's do, and Delegate Hayes, you were here before Delegate Shin, so that will be Delegate Hayes. And we're still waiting for the other delegates who have discovery bills. Please proceed, Delegate Hayes.
Thank you so much, Madam Chair, members of the committee. I do believe we have amendments to offer, Madam Chair.
Yes, Madam Chair, members of the subcommittee, there are some prepared line amendments that should be posted on LAS, and they've been distributed to the members. On line 79, after the word date, inserting a clause that states unless such person was operating a commercial motor vehicle as defined in 46.2-341.4, and then another line amendment on line 133, introduced after the word date, inserting unless such person possesses a commercial driver's license or commercial learner's permit as defined in 46.2-341.4, or was operating a commercial motor vehicle as defined in 46.2-341.4. The purpose for those line amendments would be saying that a person cannot have their charge of driving without a license or driving while suspended or revoked if they were either operating that vehicle or operating that vehicle and had one of those licenses or permits.
Are there any questions of the amendments as reported? I want to make sure, again, the bottom line of this is that, and I'm going here for it. If I may, and I'm not proud, I'm rereading this in the English that I see before me, doesn't allow dismissal of driving without a license if such person was operating a commercial motor vehicle at the time of the offense. So we've taken out all commercial drivers. And then also it doesn't allow dismissal of driving while suspended or revoked if such person possesses a commercial driver's license. So again, we're excluding all of the commercial, or was operating a commercial motor vehicle at the time of the offense. So the import of all of the amendments as reported is to exclude anyone with a commercial license. Is there any further question? A motion is in order to adopt these amendments. So moved. Here a second? Second. All those in favor of those amendments, please say aye. Aye. Opposed? Okay, as amended, Delegate Hayes, if you would explain your bill.
Thank you so much, Madam Chair, members of the committee. The purpose for this legislation, Madam Chair, is to bring and give authority to the courts to dismiss charges in the case of infractions of driving without a license. If an individual happens to be ticketed for that, unlike a lot of other infractions that an individual could be ticketed for, the courts have the discretion and they may dismiss the charges if the situation has been corrected by the time the court date appears. Unlike that, with the driver's license suspension, the courts does not currently have that authority. And so what this bill is seeking to do is to give the courts that option that they can exercise the discretion to dismiss those charges. On the way of the substitute, unfortunately, the original bill that we put forward put the Commonwealth in jeopardy of federal funds, some $92 million. And so that's why you see the carve out, because if an individual either has a commercial vehicle or has a commercial driver's license, then we must not include those individuals. And that, in essence, Madam Chair, is the bill.
Thank you. Are there any questions of the patron? Council, any observations on the bill?
Yes, Madam Chair. Madam Chair, I think that the idea of the bill is correct in that several courts, I think, are already doing this, where you come in with your license and they will either reduce the charge or dismiss it. I worry that the original language in subsection G of the final of 462301 actually will narrow it more than is what it's happening in court today, because it narrows it to somebody who has no prior violations. I have had several clients who will come in and worked really hard on their 10th driving suspended and finally got their license back after many years, and the court will dismiss the case because they've worked really hard. With this language, because we have now put it into statute, we limit that to only somebody who has no prior convictions. So I have drafted some language to fix that problem if the committee would like to hear it.
If you would please report it.
Yes. So in subsection G, and I'm sorry, I don't have the line numbers in front of me, but the way it would read is that after it would read, the court may, in its discretion, and where there have been no prior violations or convictions of this section within the past 10 years, dismiss the summons or warrant where proof of compliance with this section is provided to the court on or before the court date. And then new language, so the new language in that sentence is within the past 10 years. And the reason for that is when officers charge these, they will note on the summons how many priors they have in the last 10 years. And so that's why I limited to that. The second sentence would be to add a second sentence where there has been a prior violation or violations, the court, in its discretion, may dismiss or amend the summons or warrant where proof of substantial compliance has been provided to the court. And the reason that I use dismiss or amend is a lot of courts will reduce these charges instead of dismissing them outright. And then substantial compliance is those cases where somebody has done an amazing job of paying $10,000 of fines off and doing all these things, but there's one thing that's still keeping them from getting their license. I know there's a judge in jurisdictions I practice in that is famous for the statement, it's good enough for government work, and will give them, that person, that benefit. So I wanted to give the courts the discretion to have substantial compliance as to absolute compliance. And the reason I did this is because I feel some courts are going to read these words in the original bill to say that that's all they can do and they can't do anything else.
Delegate Hayes, upon hearing the explanation of the amendments as reported, are you comfortable with the way you're?
Yes, Madam Chair. We consider that all friendly amendments.
Move the amendment.
It's been moved and seconded that we add the amendments as reported. Any further discussion? All in favor, say aye. Opposed? Okay, so now we have the bill before us as amended. Are there any further questions or concerns that members wish to bring forward? If not, is there anyone in the room who wishes to speak for 1643? Anyone wishing to speak against? And we have no one on Zoom, so you have the final word, Delegate Hayes.
Yes, Madam Chair, members of the committee, sometimes just things in our code for some reason don't apply that we think should be the case. And in this case, this is I think a common sense fix to allow the courts to have that discretion over these charges. They are able to dismiss charges on a lot of other things, but this particular charge, they do not have that authority, and we're just simply asking to give the courts that ability.
Thank you. We operate on motion. Second. Any further discussion? Clerk, please open the roll. HB 1643 is with amendments is reported by a vote of 8-0. Thank you very much, Delegate.
Thank you, Madam Chair, members of the committee.
Thank you.
Delegate Cherry was here.
If Delegate Cherry's bill goes into another bill, that's why I'm holding it. Yeah, that's the. Yeah. So Delegate Shin. Again, our problem with the docket is both that members have dual commitments, dual or even more, but also we want to keep certain bills grouped together because we will have some incorporation. We want to make sure our discussion is complete.
Oh, okay, this morning, yeah. Thank you.
Please proceed.
Thank you, Madam Chair. I learned a very fun thing this morning during our 7:30 CC&T Sub 1 committee meeting, which is that this podium moves up and down. And it seems like maybe when Delegate...
Nice to see you.
When Delegate Green was here, it was a different height than it is for me, so we're going to adjust this. And I appreciate you all giving me an opportunity to present before you. I also want to really thank staff and Mr. Hatcher for all of his help on this because there was an enormous amount of work.
If you would report the substitute, please.
Yes, so there's a substitute.
Yeah. Thank you, Madam Chair, members of the subcommittee. The substitute's posted online. Thank you, Delegate. What the substitute does is this removes any mention of the Department of Criminal Justice Services from the bill. Originally, the bill had its powers and duties relating to this advisory council. That's no longer there. The advisory council instead was placed in Title 32.1 under the Board of Health, which would then be approving recommendations that are provided from this advisory council, excuse me. The council also was then added to 9.1 to the group of people that create and coordinate the annual statewide sexual assault forensic nursing training program. That's headed by the coordinator. So the group of people that work with the coordinator for this program, the advisory council would be part of those discussions. It also added that the advisory council will have a reporting requirement to the General Assembly every year, at least yearly, and it changed the evidence presumption under the new statute 19.2-11.6:1. It no longer phrases it as a rebuttable presumption, but a different standard for the evidence collected pursuant to that new statute.
Okay. Having heard the substitute explained, all those may I hear a motion?
I move to adopt the substitute.
It's been moved and seconded that we adopt the substitute. All those in favor say aye.
Aye.
Opposed? Now, Delegate Shin, if you would explain the bill and the import of the bill.
Thank you, Madam Chairman. I worked really hard to try and stay out of courts this year, but somehow I am back here. And you may recall that I'm sorry, Ms. Uber Chairman. I always try and avoid this, but somehow I'm here again. Last year, I didn't hear a second on that, but last year I carried House Bill 1342 with the aim of ensuring that students who are experiencing sexual assault on college campuses were able to, in a timely manner, access safe and sane or a sane examination. Through that journey, I learned that there are only 140 forensic nurses practicing in the Commonwealth today, which is a staggering shortage of access to this kind of care. It's an issue that I worked on at length in the off season, and that is the product of the bill before you today. For additional context and information, a sexual assault forensic examiner or a sexual assault nursing examiner, safe or sane, is a healthcare provider who can offer medical treatment, wraparound services, and evidence recovery for survivors of sexual assault and domestic violence. These are critical healthcare professionals who are specifically trained to treat patients who have often experienced significant trauma. And often these positions are really hard to fill, and the programs can be difficult difficult to establish, which we know by the numbers of practicing sane and safe examiners. And so often the access to forensic nurses like this can be really limited, especially in rural areas. It means that sometimes survivors are traveling hours just to be able to access a sane or safe provider. This bill would take the approach of allowing a licensed healthcare provider to conduct the physical evidence recovery kit under the consultation of a safe or sane through telemedicine, and this will allow patients to receive a forensic exam in their own communities. This legislation also ensures that evidence collected through telehealth consultation will be given equal weight as those collected directly by a safe during a criminal proceeding. And to ensure the highest quality of care, the bill establishes a process to establish education and training standards for forensic examiners providing consultation and their expertise. We hope that HB 2088 will also elevate the voices and expertise of forensic nurses in Virginia by establishing the Virginia Forensic Nursing Advisory Council under the Department of Health. The Advisory Council would establish educational and training standards and provide consultation. They would also provide recommendations to the body and support patients and providers. The difference between the introduced version and the substitute before you, as the attorney so eloquently explained, is a result of direct feedback from stakeholders as well as DCJS, and we think it better reflects the intent of the legislation to protect perks or physical evidence recovery kits and evidence during criminal proceedings. And in closing, we hope that this will be the will of the committee to report this bill. Thank you, Madam Chair.
Any questions of the patron? Any further comment of counsel?
Madam Chair, I have one thing that I want to bring up about the bill. It's line 134 through 137, which is really the only part that I will ever get involved in this because it deals with the admissibility of the perk kits. And I just wanted to ask the committee to consider adding at the end of the sentence, as long as such physical evidence recovery kit is otherwise admissible pursuant to the general rules of evidence. And what I'm trying to avoid there is a judge saying, well, I was told I can't make this inadmissible because it's a telehealth, and so you lose the ability to argue like other chain of custody issues that may come up. And so I stole that language from another statute that we have, so I would suggest that as an amendment.
It sounds like a friendly amendment. May I hear a motion?
Move the amendment as proposed by council.
I hear a second. All those in favor say aye. Opposed? Okay. Thank you for catching that. Are there any further questions, comments? If not, is there anyone in the room who wishes to speak in
Madam
favor
Chair.
of? I'm sorry, Delegate, yes, and you did use the request to speak. Delegate Batten.
Question either for the patron or council. I see, first of all, I want to thank the patron for bringing this bill forward. I think it's a very useful tool that can be applied in rural areas, as you mentioned. My concern or my question is the language on lines 70 and 71 in the substitute, where it talks about a healthcare provider as defined in, and then lists the code section there. When I go to that code section, which defines the provider, it looks like it's a very broad category of individuals. It includes everything from marriage and family therapists to podiatrists and just a broad range of people. And I guess my question is, are those people qualified to provide this sort of care in a situation of this nature?
Madam Chair, Delegate Batten, I understand your question with the definition. The definition further states that those persons defined in 8.01-58.1.1 also have to provide forensic medical examinations to victims of sexual assault. So this is not to be redundant, I don't think like a podiatrist would be providing those services. So I think that the definition itself, it is a broad definition cross-reference, but those people also have to be providing those services. Does that make sense?
Yes.
Further question, Delegate Batten?
Thank you.
All right. Thank you for that clarification. Any further questions? If not, again, is there anyone wishing to speak in favor of 2088? Please come forward. You each have, please come forward so I know how many will be speaking in favor. I see two people, 2 minutes apiece, up to. Thank you.
Fantastic. Madam Chairman, members of the committee, my name is Davis Gammon, and I'm from the Virginia Hospital and Healthcare Association, and we support the bill and really thank the patron and staff for all of their work on this really important issue. As was mentioned, forensic nurses across the Commonwealth provide incredibly important services to victims and to their communities. Unfortunately, they're not everywhere, particularly in our rural and underserved communities. There is a gap, and we believe that this bill will help us fill that gap and provide really critical services to victims so they're not traveling incredibly long distances to get the very, very critical services that they need in the communities in which they live. And can receive their kind of community support as well. To answer Delegate Batten's question, which I think is a really good one, so from our perspective, it's the healthcare provider as designated by the Commonwealth's attorney in the community. That still is listed in another place in the code. I'm not a lawyer, but they have to have some kind of designation to collect the evidence from the Commonwealth's attorney. That's kind of the only kind of caveat that exists for sexual assault forensic examiners, and that still would remain unchanged. So there is that kind of backstop to make sure that these are qualified, licensed, appropriate healthcare providers. Yeah, we're not talking about marriage and family life counselors. So we do hope it is the will of the committee to support the legislation.
Thank you.
Madam Chair, members of the subcommittee, Lauren Schmidt on behalf of the Virginia Sexual and Domestic Violence Action Alliance. I believe that Davis covered all the points. We support this bill very much. Thank you.
Thank you. Is there anyone in the room wishing to speak in opposition to 2088? If not, we have two individuals online. First one, Molly Montague from Rain.
Thank you, Madam Chair and members of the committee. As mentioned, I'm Molly Montague with the Rape, Abuse, and Incest National Network. We're the nation's largest anti-sexual violence organization, and I'm glad to be here today to support advancing more access to forensic medical care for survivors of sexual assault. As you've heard, Virginia faces a challenge in how to collect evidence of sexual assault when there aren't enough trained nurses to come to every survivor. I want to give you an example of how this plays out. A person rapes someone, and let's say they're out in Washington or Northampton County, that survivor needs to go and get a forensic medical exam. They go to the nearest emergency room, which might already be a little ways away. The survivor needs the medical exam to address their injuries, collect evidence in case they want to report the crime, and to get support for the trauma that they've experienced in that assault. And they need a sexual assault nurse examiner. Unfortunately, as you've heard, in Virginia, there are simply not enough SANEs to go around. This means that survivors have to wait for that sexual assault care and for that SANE nurse to become available. It also means that the SANEs themselves are driving tremendous hours to get to these patients that need their care, mileage that they often have to cover themselves. SANEs undergo training on the collection of evidence, which has been shown to have improved outcomes in sexual assault prosecutions, and the trauma-informed support that they provide in a moment of crisis has a tremendous impact on their patients. The lack of available SANEs disheartens survivors when it means that they're told they have to wait hours for an exam to even begin, or perhaps told they must travel hours to a facility prepared to treat them, maybe still sitting in the clothes that they were raped in and with visible or invisible injuries. They want to go home, they want to take a shower, they want to maybe begin to process what's happened to them. Some survivors don't have the resources to wait or to travel. Some don't have the bandwidth, and some skip this very crucial exam. Thanks to telesane programs, nurses can conduct the exam and the telehealth support from a remote SANE nurse who has specialized experience necessary. Other states have telesane programs and have seen great success, including Arkansas and Massachusetts. Please. Thank you for your consideration of the bill, and we hope it's the will of the body to support it.
Thank you. And we also have online Dr. Bonnie from Bon Secure. Excuse me, Dr. Bonnie Price. Please speak.
Good afternoon, Madam Chair and committee. My program is the Bon Secure Violence Response Team, and we serve a large area of the state of Virginia and have been caring for patients impacted by violence for the last 32 years. Delegate Shin mentioned 140 forensic nurses, and I have 16 of those on my team. We're very blessed that we have that number here, but there are many parts of the state where they do not have access to forensic nurses. Teleforensics is something that is being successfully used across the country. And there have been a number of instances where people who have been victims of violence will not leave their communities and will just forego their opportunity to have evidence collection, to have a medical exam, to receive support after being brutally violated. And so I support this bill.
Thank you,
And
Dr.
Thank you.
Thank you, Doctor. Seeing no one else on Zoom, Delegate Shin, before you have the last word, I do have a speaker's letter that the HB 2088, if we act favorably on it, is to be re-referred to appropriations. So if you'd like to address that at all in your final comment.
Yeah, thank you, Madam Chair. I think that with the substitute, we hope that when they reassess the financial impact statement, it will actually be a lot less because we're not asking for it to live under DCJS, but instead we're going into housing it at VDH. So thank you for your consideration. I really appreciate it. Thank you.
Thank you. Time for the committee's discussion. Any further questions, comments? We operate by motion.
Move to report and refer to appropriations.
As the substitute,
As
amended.
As substitute as amended.
Any further discussion? Clerk, please open the roll. Members, cast your vote. Okay. HB 2088 reports unanimously 8-0. Substitute as amended to appropriations. Okay, I'm still trying to keep track of bill members with similar bills, some of which will be incorporated all together as I look at the docket. So as I look at who's in the room, is Delegate Early in the room? Please proceed. You have HB 2347.
Yes, ma'am. Madam Chairman, thank you. Members of the committee, subcommittee. This is HB 2347. There should be a substitute. Maybe it's already out there.
Yes, Madam Chair, members of the subcommittee, a substitute has been distributed to members. This substitute actually adds code section 18.2-472 to the bill. Originally, the bill was just extending the statute of limitations, so it only had 19.2-8 in it. And the changes made to 18.2-472, it looks like it's a lot, but some of it is grammatical updating, but the biggest part is that it's adding public employees to the list of persons that could be charged with this offense. Currently, it is a clerk of any court or any other public officer. So now it would be a clerk of any court, any public officer, or any public employee.
Thank you.
Is there any questions on the substitute? We operate by motion. That is an amendment, correct? Substitute. That is before me. Okay. Any further questions on the substitute? And all that operate on motion? Move the substitute?
Second.
Second. All those in favor say aye. Aye. Opposed? Please proceed and explain.
Thank you, Madam Chairman. All right. Ladies and gentlemen, members of the committee, this is a very simple bill with a simple aim. So essentially, it aims to make sure that we have the ability to prosecute someone who has fraudulently and intentionally violated the public trust, which unfortunately we have seen in the past lead to devastating consequences. And the motivation here is just to make sure that we have the ability to prosecute and protect Virginians from, thankfully, that fairly rare person that would abuse power. So just to walk through it very, very briefly, the key part is that currently the Code of Virginia only has a 1-year statute of limitations for officers or public employees who create false entries or destroy evidence records. And what this is doing is extending that to either 5 years or, the most important part, 2 years after the existence of the act and the identity of the offender are discovered. That's really the key point of this. So what's in it? Well, let me just walk through the language very briefly, and then I'll give you sort of the backstory of why this is here. So again, in the change to 19.2-8 is referring to 18.2-472 and saying for a violation of that statute, the statute of limitations is going to be either 5 years or 2 years from the discovery of it. And the only reason there's a change to 18.2-472 is to make sure that it's, we were struggling to find a definition of public officer, so we wanted to make sure that we were broad enough to catch the folks we were talking about. So why is this bill here? Why do we do it? What's an example of this? So we're going to have a bill later, that you're going to see a bill later this session carried by Delegate Sullivan, which is a wrongful compensation bill for a guy named Marvin Grimm. And it's not just about this case, but it's an example of it. Mr. Grimm spent 44 or maybe it was 49 years in prison based off a conviction in 1975. He got his writ of actual innocence just a couple years ago, was released, and actually lives in the county that I partially represent. If you go back and look at his case, and unfortunately he's not the only one that has this, but there was what appears certainly to be fraudulent destruction of records and misrepresentation of things, and that was part of what led to his wrongful conviction. And obviously, his example is a horrendous example because the guy lost 44 years of his life. So the point is this, that if that person who was at the time at Department of Forensic Science was alive today, that person would not be able to be prosecuted because we're so far past the time. So again, this is pretty simple. It's essentially just saying, even if it's years later, once we discover the person and discover the act, then it tolls then it gives you some more time after that. So I think of this as essentially a public integrity bill, a public trust bill. And just to be very clear, I think this is obvious by the text, but this is not creating a new crime. It's not upping any penalties. It's just making sure that, number one, any public employee is included in the folks who we're talking about, and then that the statute of limitations is extended so that somebody can't wrongfully escape accountability for it. So I'm happy to answer any questions, but that is what the bill is and what it does.
Are there any questions?
Madam Chair, I have just one
Yes,
clarifying question. Can you, and my question for the delegate is, who is included in public employee? Like, is there a definition of public employee somewhere else in the code?
I may ask counsel about that. So one of the reasons we added it is because when we were thinking about the particular situation, we were struggling to find a clear definition of public officer, actually. And we thought, the net we're trying to cast is, anybody who has some position of public trust employed and paid by, and, has some power in that sense. Because really what this is sort of an anti-abuse of power amendment, but I may, defer to counsel on that.
Madam Chair, I had the same thought, and I searched, and there was not a definition in the Code of Virginia of public employee. There's not a definition of a public officer either, but that comes from another statute. Both of those come from another statute. It's 18.2-168. So it is used in other areas of the code. I think it would be given its general meaning that if you work for the government, you are a public employee. And certainly if you have the access to something in order to do these things that are listed on here, you would certainly, even if were a janitor, but you got on the computer in order to make a change that you're employed by the government, even as a 1099 or something like that. So I don't see an issue. I'm not sure we could come up with a good definition for it.
Yeah, and that's Delegate Cousin. That's basically my impression as well, that it would sort of have its normal public or normal meaning. And again, I think this is obvious, but this is not for somebody who makes a mistake. I mean, there's already the standard here of fraudulently and intentionally, all this sort of thing.
Is there any further questions? Comment from council? Anyone in the room speaking for? Speaking against? I don't believe I have anyone online. Yes. Now it's having no one just in the public speaking for or against. Delegate Cardoza.
Move to report. Mr. Chair, I'd like to speak to the bill.
The motion was to report.
Was there a second?
Speaking to the motion.
I can speak to the motion.
Okay, I have a motion to report. Is there a second? Second. It's been moved and seconded that we report. Delegate.
I guess I'm struggling with the why, and I'm bringing a bill this year to do some further investigation on Mary Jane Burton, and it's pretty well documented that first came to light back when Mark Warner was governor. And so, that's when, if this were law back then, that would start tolling it. Now, she's passed away, of course, and so we don't know her intent.
Right.
But it just feels like to me that someone like that, something that's egregious, that you'd see these mistakes or probably intentional mistakes that I think we're going to uncover, that this law would protect individuals such as that. I don't know what we're going to uncover with that, so I'm concerned. I'm struggling really with the why that we're doing this, given that case is out here.
I'm sorry. We are now in a motion. Thank you. Are there any other further comments? And I do apologize that I didn't give you the final word, but then we hadn't had testimony. And so with that, is there anyone else who wishes to speak to the motion? I'm going to take the prerogative to the chair to say that I also have great concern that putting in a statute of limitation at this time, while you have an individual with Mary Jane Burton being an excellent example, but when I see other examples, sometimes what you see is just the tip of the iceberg of multiple acts of someone who has had years of responsibility in a given area. And when I look at this language, that discovery of one act starts the toll. And that bothers me exceedingly about not being able to really look at the magnitude of what might be involved, particularly for those who have been victimized by multiple acts in Mary Jane Burton's situation. It's certainly reasonable to assume it's over a 20-year period. Are there any further comments before we take the vote? Delegate Cousin.
I have a substitute motion, Madam Chair. So just based on the concerns that have been raised, I move to gently lay this on the table.
Second. Okay. It has been moved and seconded to lay the bill on the table. This is not debatable. It's a recorded vote. Clerk, please open the roll. Members, cast your vote. Now, I'm sorry, the board incorrectly reads removed from the table. The board needs to be table. Okay, please cast your vote on the motion to table HB 2347. Please close the roll. HB 2347 is tabled by a vote of 5-3. Thank you, Delegate Early. So now, who do we have in the room? Long-standing. Okay, so we've got Delegate Munden King is here. We can proceed with Delegate Munden King having to do with trafficking, and then we will proceed to the bills having to do with discovery, unless.
I think Mike Cherry.
Wait, can you wait? Hold just a moment as I try to see who's in the room. Who is in the room with the discovery bills? Making sure we've got. And I really want Delegate Thomas here, so we are going to turn to the trafficking next. Please proceed, Delegate Munden King.
Thank you, Madam Chair. And I believe we have a substitute.
Yes, Madam Chair, there's a substitute. It should be posted online. We'll see if that worked. What the substitute does is it removes code section 18.2-172, referencing forging and uttering, and 18.2-346.01, referencing prostitution, solicitation, commercial exploitation of a minor from the list of qualifying offenses. The definition of sex trafficking will now read, sex trafficking means the recruitment, harboring, transportation, provision, obtaining, patronizing, or soliciting of a person for the purpose of a commercial sex act that is induced by force, fraud, or coercion, adding, or in which the person induced to perform such act has not attained 18 years of age. Subsection B of 19.2-327.17, Romanet number 3, we added the word place to that, so it would read the approximate date, time, place, and manner in which the petitioner became a victim of human trafficking. And subsection D of 19.2-327.17, there was a drafting error referencing a 19.1-11.01 section. That should have been a 19.2 code section.
Is there any discussion on the substitute? All those in favor of adopting the substitute, please say, indicate, please, everyone, say aye. Aye. Opposed? Substitute is before us. Delegate Munden King, if you would speak to the substitute.
Yes, speaking to the substitute, thank you, Madam Chair and members of the committee. So House Bill 2393 is a bill that will give victims of human trafficking the chance to clear their records and access the support they need to move forward from some of the most heinous acts that we've seen in human trafficking. A few key parts of this bill include expanding definitions. So some of our code focuses on sex trafficking, and we know that human trafficking, including forced labor, is a pervasive in the Commonwealth. And so expanding those definitions will be able to help more people clear their record. This also includes a streamlined legal process that clearly and simply puts the terms that those who are applying to have their records cleared need to attest to. It has victims protections and clear guidelines on restitution and refunds. And so I know this committee is very familiar with how heinous the crimes of human trafficking are, but I just wanted to take a moment to thank all of the advocates who worked on this and who came to me and asked me to carry this bill, because I think that the opportunity to regain their lives is an important one, and this is a step in the right direction.
Thank you, Delegate. Are there any questions of the delegate? Council, is there any comments before we turn to the public?
Madam Chair.
Concerns? Yes, Delegate Williams.
I'd have a question for the patron, and I'm not sure if she knows, but do you know the differences between your bill and Delegate Cherry's bill, since we're looking at them together?
Thank you, Madam Chair. With us introducing the substitute, I am not aware of whether the delegate has made those changes as substituted, but the original versions were very similar.
If I may respond, my review of the bills is that they were identical, and again, the guidance is that, and this is just straight parliamentary guidance, has nothing to do with the Virginia General Assembly, is that you really shouldn't ever pass out multiple bills that are similar, so that they started out identical. Now with these amendments, it would be appropriate to have a motion before we act on this bill in a final matter to incorporate Cherry's bill into this bill. And I know that we, as courtesy, also guidance, I believe that Delegate Cherry is comfortable with that incorporation. One. Okay. Thank you. Again, let me be clear, though. I certainly, over the years, there's been once or twice when I have said, no, I do not want my bill incorporated into another bill. I would rather see it not passed. Because for whatever reason, there was something about the other bill that I really did not want to adopt in what I thought the law should be. So that option is always in the patron's hand not to be incorporated. But very often, as it always happened with me, then I lost my bill, but I did what I felt was right.
Madam Chair, I would move to incorporate Cherry's bill into the Munden King's.
Second. It's been moved and seconded that Delegate Cherry's bill, which is by number
2227.
2227, will be incorporated into HB, which is before us, 2393. All those in favor say aye.
Aye.
Opposed? No. Okay. And this is a voice vote. It's as an amendment in parliamentary. Okay. Please now proceed to the substance in your discussion.
Thank you. So there are people here who can better tell their stories, but the bill introduces critical updates to strengthen and broaden the legal protections for those who have been victims of trafficking. It reflects a collaborative effort, and by passing this, we would be removing the burden of criminalization that many victims face and providing access to survivors to access many benefits throughout the Commonwealth that a criminal record can be a barrier to. And this is also an opportunity to help on a pathway to restoring dignity and independence and self-reliance. And I hope it will be the will of the committee to act favorably upon the bill.
Thank you. Seeing, no, are there any further comments from, I lost track of whether or not the committee has been able to ask any questions you have. Yes, Delegate Batten.
Thank you, Madam Chair. Question, I guess, either for the patron or maybe it'll be someone who's coming to speak to the bill. First of all, I want to thank you for bringing this forward. I was noticing, some of the, obviously, the crimes and whatnot that would be covered in this area. And I noticed that one of them, and I understanding that traffickers often use, substance abuse problems and whatnot as a means of controlling their victims. I see that, if you have a DUI and you're under the age of 21, that's forgiven. But if you're over the age of 21, then that's not covered. And I'm just curious what the delineation was there and what the conversation was that pulled that particular part out and not the over 21.
Sure. I'm happy to let counsel speak to that, but can you refer which line you're referencing?
Well, it's in, I don't have my lines up right now. Hang on. It's, I think, line 23. It's the code section 18.2-266.1, and that's the DUIs under the age of 21, but that doesn't cover the DUIs if you're over the age of 21. So I'm just curious why the over the age of 21 is omitted from this section.
Well, I'm not a lawyer, but when you're over the age of 21, you are allowed to consume alcohol, and often with children, it's forced upon them. But happy to let counsel speak to some of the thinking around that.
Madam Chair, Delegate Batten, I'm not sure. I'm sure there was some policy thoughts in that, so I don't know the policy behind it, but I think probably the biggest difference is 18.2.266 doesn't, .1 does not serve as any predicate offenses for any enhanced penalties, whereas 18.2.266 would. And so by removing a conviction for 18.2.266, the adult DUI, it would likely cause some issues down the line versus with this, it doesn't serve as a predicate. And it is for those, exclusively for those under the age of 21, who are the only people who could be convicted of this.
Thank you.
Thank you, Delegate.
Thank you, Madam Chair.
Any further questions of the committee? If not, I would like to turn. Yes, Delegate.
One unrelated question to that, but for the question for the patron or for counsel, so the victims, as they're receiving restitution, where's the funding come from for that? And are there adequate funds available, considering that, unfortunately, in the Commonwealth, we do have a really large number of individuals who would be covered by this?
Madam Chair, Delegate Batten, if the restitution is wiped out under this, it was referred to the victim fund or the criminal injuries compensation fund, and the bill does allow the date of accrual to start when the restitution, when the writ of vacatur is granted. So victims don't have any issues with time limits having run.
I think my question was...
Delegate Batten, please go through the chair.
Yeah, Madam Chair, I think the question is, what is the source of the funding for the restitution? I'm sorry, can you repeat that? You might have said it.
It's from the CICF.
Okay. Thank you, Madam Chair.
And again, thank you. And again, I understand, listening to your questions, that we're talking about not restitution, but in fact just refunding any fines or restitution that was paid. We're not talking about an award of restitution.
Madam
Chair, we are just, so it's clear, this isn't a case where a defendant was ordered to pay restitution. They have either paid none or some of, but not the full amount, and then they are granted this writ. The remainder of that restitution would be available to the victim through the CICF as opposed to through the offender.
follow-up question.
Please, Delegate Batten.
Thank you, Madam Chair. I guess question for council or whomever can answer it. Is there adequate funding for that, or would there be additional budget language that we would need to include to ensure that this fund is adequate to restore these individuals?
Yeah, the CICF is appropriated money generally through the general fund, so I have no idea what the level of CICF or if there would be any impact to them based on this, this slight increase in restitution that someone may receive.
Thank you.
And Madam Chair.
Yes, Delegate Mundan King.
If I can add one, I'd like to thank the delegate for those questions and just say that in the case of funding, I'm so grateful to have bipartisan support from across both chambers and including in the Attorney General's office. The governor has spoken extensively about this, so I'm quite sure that whatever the funding is needed to help these victims be restored, we can find some agreement on it.
Thank you very much, and again for underscoring the breadth of support. But I just want to clarify for the work of this committee that we are not talking about adding restitution for the person who has been victimized by trafficking. We are talking about any restitution that might have been ordered in the course of a crime for which the victim of trafficking has been convicted. So I don't want the impression to be that in addition to the I don't say the word right, vacatur of the offense of someone who was the victim of trafficking who was convicted of that offense. We quite frankly, having worked on this issue for a lot of years, it is incredible progress that we are recognizing the victimization that is involved with trafficking and vacating the charge or the conviction. But we are going another step and we are saying somehow that there's also going to be restitution for that individual. I just want to be clear on, as we're talking about restitution, about to whom that restitution is owed. Hopefully I didn't muddy it up more. Now I think we are at the point of hearing from the testimony. All those who wish to speak in favor of HB 2393, please come forward so I can see how many there are. I see 3 speaking. If you could all share 5 minutes, please. Thank you.
Good afternoon, delegates. Thank you. My name is Desiree Trail, and I am a survivor of human trafficking. I thank you for allowing me to appear before you today. I am here to advocate for the passage of vacator bills HB 2393. And I thank Delegate Mundan King, Delegate Cherry, and Delegate Delaney for sponsoring these bills and for the hard work for HB 2227 as well. So thank you. I'm a 54-year-old disabled single mother and a survivor of human trafficking. I serve as a survivor leader, public speaker, and consultant with Global Centurion, the Virginia Coalition Against Human Trafficking, the PD 16 Human Trafficking Task Force, and the Central Virginia Justice Initiative in Fredericksburg, Virginia. I have conducted trainings for federal and local law enforcement, and my survivor story can be found in the Department of Justice website at the DOJ Survivor Story. Several years ago, I came to testify for vacator, but it was tabled at the last minute. This was heartbreaking, but I was encouraged by several delegates who are here today to keep coming back. I testified for HB 1426, which Delegate Ann Farrell Tata kindly sponsored, and SB 1147, sponsored by Senator Jennifer Boysko. I am thankful for their efforts as we successfully passed the Virginia Human Trafficking Healthcare Training Bill. I take pride in being part of that life-saving legislation, but when I say we, I mean not only myself and members of the General Assembly, but also my colleagues, survivor sisters and survivor brothers, and advocates across Virginia who worked tirelessly on those bills. We are now asking the House Courts of Justice Criminal Subcommittee to vote yes for vacator, which is urgently needed here in Virginia, especially in marginalized communities. Virginia has received an F from Shared Hope International for its lack of support in improving the lives of human trafficking survivors and prevention. And I believe today we can do better this year, and I hope that all of you will agree. My charges include drug possession, grand larceny, and prostitution. Please keep in mind they are over 20 years old. While I was trafficked by various drug dealers who were never prosecuted. At that time, I did not recognize myself as a victim, and I was trafficked on and off for years, since I was 20 years old. I understand the complexities regarding the one charge that is not listed, which is child neglect, which was happening at the time of me being trafficked. In my case, it was unintentional, and believe me, I have paid the price for over 20 years, and I'm happy to say that I've been reunited with my child, and he is 25 years old today. I can attest to the pain of being denied the right to be free from the bondage of my past. I have sought vacator status or a pardon since 2016, and it has been a great hardship for me, especially with my health issues, which include complex PTSD, depression, bipolar disorder, fibromyalgia, and neuropathy. Despite these challenges, I continue to mentor other survivors, help draft bills, and testify at the General Assembly each year for the past 3 years. Finding adequate, safe housing has been even more difficult. The low-income community that I live in is plagued by constant shootings and drug activity, which trigger my CPTSD regularly. And I must say that I am a recovering addict, and it is very hard to live in a community like that watching this, as well as to protect my 15-year-old daughter. I must share my story with strangers each time I seek better housing, and I face constant denials due to my record, which, remind you, is over 20 years old. This is humiliating, and all I want to do is to raise my 15-year-old daughter in a safer environment. I am just one of thousands in our country who have survived horrific trauma starting at ages 3 to 6 years old for myself of childhood sexual and physical abuse, foster care, and an adulthood filled with sex trafficking, domestic violence, multiple suicide attempts, homelessness, and ongoing trauma compounded by a history of self-medicating. I have worked diligently to recover, one day at a time, but I have been struggling lately since the passing of my dear friend and survivor sister, Barbara Amaya, who died a year ago on January 20th. She helped draft and testified vacator in Virginia back in 2014, but that bill never passed. She died without ever receiving justice for charges accrued from being trafficked as a child, and I'm here to ask you to honor her memory by passing this bill today.
Thank you very much. Since we have, thank you for laying out the full impact of crimes that were, of which you were convicted while being part of trafficking. If you would identify just your name and who you are representing, please.
Yes, Madam Chair, I'm Fatima Mowahed with the Humanization Project, but I'm the state representative for Survivors for Justice.
I'm sorry, but on behalf of the decorum for all the committee, your name and the group you are representing only. Thank you.
Yes, ma'am.
Your name?
Lauren Schmidt with the Virginia Sexual and Domestic Violence Action Alliance.
Thank you. And is there anyone in the room who wishes to speak against HB 2393? Online, we have two individuals speaking for 2393. First, Christina Lauren from the Coalition Against Human Trafficking. Christina?
Thank you, Madam Chair and members of the committee. I'm Christina Lauren, Board President of the Virginia Coalition Against Human Trafficking. I'm a public attorney in Hampton, Virginia, and I hold a Master's of Law in Human Rights, along with lived experience expertise in human trafficking. This past year, the coalition convened a working group consisting of stakeholders and lived experience experts to address updating Virginia's vacator statute related to criminal record relief for human trafficking survivors. This legislation is crucial in providing the improved remedies at law for the injustice victims of human trafficking have suffered. In addition to expanding the number of qualifying offenses, the legislation aims to make the vacatur petition more accessible and easier to understand for survivors, Commonwealth attorneys, and judges throughout the process. These changes will bring Virginia closer to the current best practices recommended to provide human trafficking survivors with the best chance to achieve stability while building full and healthy lives. We respectfully request that the Code of Virginia be updated to include these recommendations. I thank you so much for your time and consideration, and we hope it is the will of the body to support the bill.
Thank you. And also online, Patrick McKenna, also from Virginia Coalition Against Human Trafficking.
Good afternoon, Madam Chair, members of the committee.
We can hear you. You just, since we have seen your face, and when you come back on, I think we have lost him. But if you can redo the connection, he does not have to show video if his signal is weak, since we have already seen him in person.
Thank you, Madam Chair. I've just echoed the comments of the previous speakers and would note that this is an effort has truly been a bipartisan effort. So having represented survivors of human trafficking for a number of years now, both legally and on the policy side, this is a great step forward. And thank you for the committee's time in considering the bill.
Thank you. Seeing no other speakers, Delegate Munden King, you have the last word before the committee acts.
Thank you. Thank you, Madam Chair and members of the committee, for taking the time to hear this bill. And I just want to thank the survivors and the advocates who are here today for coming from near and far to share their stories and fight for this bill. And I hope the committee will act favorably upon this measure.
Thank you.
Move to report with substitute.
Second. Move to report with substitute, and again, that's as amended because that's the incorporation amendment. Is there any discussion? Clerk, please open the roll. Cast your vote. HB 2393 reports with substitute, I'm going to say as amended, which incorporates Delegate Cherry's HB 2227.
Thank you, Madam Chair, members of the committee.
Thank you. Are we ready for discovery? All discovery people are in the room. Yes.
Jay Lethbridge is sitting over there.
But he did just come in, and others have been waiting for discovery. So we're going to do discovery, and then we'll do Lethbridge, and then you. Okay. So let us first do HB 1627 with Thomas. Please proceed.
Chair, members of the committee, HB 1627 is a small change to the code that solves a problem where right now it's not completely clear when a criminal record or by whom needs to be transferred. So the issue is that what this bill does, it clarifies a criminal record shall be provided by the Commonwealth attorney, so we know exactly who needs to do it, and it eliminates any ambiguity in the code. As of right now, certain parties are claiming that no one knows when criminal record is supposed to be, or who is supposed to transfer or has the onus to transfer the criminal record. So that's what this clears up.
Thank you.
That's really it.
Are there any questions, any amendments from council or from the committee? I guess, go ahead.
Question for the patron. Do you know what the FBI criminal report looks like? Do you know, I guess what I'm saying is, are they going to tell us the criminal record by writing it down, or are they going to provide the NCIC reports?
So, I mean,
well, staff was shaking their head, so maybe Mr. Mutnick knows.
Madam Chair, if I can respond. Well, unless staff wants to knock it out of the park, as usual.
Do you know which one?
No pressure.
Whatever the
I'm
best
not
answer
sure
is.
I'll knock it out of the
Pressure.
park because I in reading this when I first read it, I was not sure that it did require them to provide you an actual copy in the language that is used. I know that was the intent of the bill, and I think 99% of the people would read it that way, but I always look at things in a way that they may not, somebody else may read it, and I'm not sure the word copy is strong enough to say that they are actually supposed to hand over the report that has all the information on it. And so not sure I have a stronger word in my brain right now, but I would say that I'm not sure the word copy is strong enough for what the patron wants to do.
Madam Chair, if I may phone a friend, so I hope it's a friend, not a friend of me right now. Sure. All right.
So Tim Coyne, I'm Deputy Executive Director for the Virginia Indigent Defense Commission, and this is a commission-recommended bill. And the intent is to actually have the actual copy of the criminal record, defendant's criminal record, our own client's criminal record, provided to us, including the FBI information. That's why the references to the National Criminal Information Center, NCIC, and the Tier 3 system, to incorporate not just the Virginia criminal record, but the nationwide criminal record as well. The intent is to get a copy.
Delegate Williams?
Just follow
We thought
up.
using copy would do it.
So it sounds like it's almost like creating if the criminal record, whatever form it's in, becomes discoverable at that moment. It doesn't matter what form necessarily, but if they collected the criminal record, then a copy of that should be provided.
Correct, yes. But the problem is now some Commonwealth attorneys are recreating the record and taking the convictions, and that's there can be error in that. And I think it's critical for defense counsel to actually see the actual record, because that actual record has references to out-of-state codes, for example, dispositions that may not be clear. And if the Commonwealth is just recreating it, that doesn't solve the problem. We really need the actual criminal record itself.
Copy thereof.
Madam Chair.
Yes, please.
So that's what I would like too, which is why I'm trying to clarify what exactly we're going to be given if we know that answer.
Okay. So one
if you would go through the chair, please.
To provide physical or electronic copy on line 270. Is this the right one? Yeah, 273.
I'm not trying to mess
Don't
with
know
your
if I'm in a
bill.
position to make it's just an amendment, so add.
You got to say Madam Chair first.
Madam Chair, sorry.
Yeah.
Line 273.
We would entertain a friendly amendment, Madam Chair, on line 273.
Counsel?
Madam Chair, I would suggest putting after the word A, before the word copy, physical or electronic. And I think that makes it very clear, because I also bumped on the language in the statute where it says pursuant to the rules of court for discovery, because the rules of court can tells the Commonwealth they don't have to actually give you a copy. And so that's why copy is just such a wide word. But I think if you say physical or electronic, that means that we are intending that that the defense attorneys get a hard copy or a scanned and emailed to you copy, although maybe state police will have a problem with that. But at least you get a hard physical copy of the record. And that's, I think, what the intent of the bill was.
Yes.
Okay. You have heard the suggested amendment. Is there a motion? Okay. Moved and seconded that on line 273, after the words provide A, we insert physical or electronic before copy. All those in favor say aye. Aye. Opposed? Okay. Delegate Batten, did you? Mm-hmm.
Yes, thank you. Thank you, Madam Chair. Question for probably counsel. Looking at line number 275, is there any way or need, I guess, to clarify exactly to whom the copy is being provided, that it's only going to the defendant's counsel, no further dissemination?
Madam Chair, I know in the discovery rules, there are rules that allow for the court to either make something restricted dissemination material and or enter a protective order over certain pieces of discovery that is turned over. But there's nothing in this statute that would stop the dissemination to at the defense attorney.
Madam Chair, follow-up. Is that something that is of concern to the patron? That I'm assuming, and maybe incorrectly, that you would want this record only to go to the defense, not to be shared elsewhere?
I mean, I'll tell you right, Madam Chair, I will answer the delegate's question saying, I do dirt law, but when this was brought to my attention, it seemed like an injustice that we didn't really know who was supposed to give what record. So if that gives, Madam Chair, if that gives the delegate confidence that the system's working appropriately and my friends to the right are okay with it, then that would be a friendly amendment from my perspective.
Thank you, Madam Chair. I'd like to offer that as a friendly amendment. And I'll obviously defer to counsel, but again, the intent is to clarify, to whom the copy is being provided, and that it's only to the defense's counsel with no further dissemination.
Well,
I don't know if there needs to be further dissemination, but just want to clarify to whom it's going. Yeah.
The question that I have in pursuing, listening to your concerns, when I look at the beginning of this statute, 92.2, on line 13, it starts with a criminal history record information shall be disseminated, whether directly or through an intermediary, only to. So every subsection after that is controlled by only to. So that I don't think the concern about inappropriately sharing is covered by the whole structure of the statute. Counsel, please correct me if I'm wrong.
Madam Chair, I would agree that the way the statute is written is it looks like there's 50 entities or persons that are stated explicitly of who dissemination can be given to. And there also are applicable rules, court rules that say you shall not give it to the defendant themselves.
Mm-hmm. If I may follow up, I would say, Delegate Batten, that the reason why I've been schooled on this committee to look for that sort of thing, if we put some sort of, and I'll use my family's phrase, belt and suspenders, and say in this new section that only to, then it's going to say, well, in the other ones you really didn't mean it. So that's why I'm going back to the structure of the underlying code section.
Thank you, Madam Chair.
Are there further questions, concerns? If not, I have two amendments that I would suggest. The first amendment, and for both of them, I would draw your attention to the work that's been done by Delegate Davis in his bill, HB 2314. And in HB 2314, which is identical to this bill as introduced, except for lines 15 through 33, which permit that you may take a photograph as a way of getting a copy of the information that you're entitled to. And I think that this is an important provision, and rather than reporting out two bills, which again is not parliamentary, it's frowned on, what I would suggest is that in the motion to incorporate HB 2314, we also then have a second motion that says that we amend 23, and we amend 1627 with that first provision of 2314, and with the amendment to the. But I'm not going to report two bills because I'm not supposed to. Yeah. So this gets the content all in one bill. And again, that's the goal, is that if you've got bills all in the same subject area, you're trying to put them together.
I would consider that a friendly amendment, Madam Chair.
Again, I don't. If the patron said, no, that's going to encumber my bill in some way, then that becomes another issue. So if the patron regards that as a friendly amendment?
I do, Madam Chair.
But it has to be made by someone. And
Second.
So it's been moved and seconded that the language in HB 2314, lines 15 through 33, be amended to HB 1627. All those in favor, any discussion? All those in favor say aye. Aye. Opposed? Then a second amendment is in order, which is to incorporate HB 2314 into HB 1627.
So moved. Second.
Any discussion? All those in favor say aye.
Aye.
Opposed? Okay. And it is my understanding, and while we have your bill before us, if I may, it's my understanding that Delegate Davis wishes to strike 2312, and it's, if you would speak to it.
I'll move the strike. HB 2312.
Okay. All those, and this is then incorporated as we go forward? Thank you.
Thank you.
All those in favor of striking, accepting the six, I don't think we have to vote on that. We do. We do, okay. Thank you for, Madam Clerk. All those in favor of striking 2312, please say aye. Opposed? Recorded vote. And,
Madam Chair,
at the request of the patron, HB 2314 is stricken by a vote of 6-0.
I thought it was 2312. 2312.
Yes, I'm sorry.
So we need to change, yeah.
Not 14. No, 14 is incorporated in, which we've already done that. If you would correct the vote, thank you. And of course, I should have said destroy the roll. Okay, now the correct, as reflected on the board, all those in favor of striking 2312 at the request of their patrons, please vote yes. Please vote on the board. And 2312 is stricken by a vote of 7-0. Thank you. Now, I think that is the work on the bill. Any further questions before we turn to those who speaking for the 1627 as amended?
Madam Chair. Tim Coyne again, Deputy Director of the Indigent Defense Commission. Again, we do support this bill. Commission recommended this. Throughout the Commonwealth, we have 29 public defender offices around the Commonwealth, plus we also oversee and certify a number of a lot of court-appointed attorneys. And when they have to go to a Commonwealth Attorney's office to review a record because they're not provided a copy, it's an incredible time waste of their time and resources. It also has the impact, especially with regard to court-appointed lawyers, of disincentivizing them from continuing to do this work. That if they have to travel this distance and then spend time reviewing the record, taking their notes without being provided an actual copy, we're losing people off the court-appointed list. And this is one of the reasons, because this is a real pain point. We believe that this is a fair resolution, and this would require the Commonwealth to provide the actual copy or electronic copy of the criminal record, and we fully support this.
Thank you. Is there anybody else wishing to speak for HB 1627? Anyone wishing to speak against? I don't believe. I have one person online. Dwayne, yes, please come forward. I didn't see you initially. Identify yourself.
Hi, I'm Tracy Quackenbush Martin for the Virginia Association of Commonwealth's Attorneys. And I'm speaking only against the portion of this bill that incorporated HB 2314, the changes to Article 4.3 for electronic discovery.
So I want to be clear in what is before us.
That line. Okay. Forgive me, that's not been incorporated. I will wait my turn.
Correct. Thank you. Whew. We're trying to do this right. All right. Seeing and again online, I have Dwayne Barron who has registered from Justice Forward. Please proceed.
Madam Chair, thank you. I also, public defender, practice in jurisdictions where they provide electronic discovery. And one of the things we don't get is the NCIC report, don't get the criminal record. And so this would be very helpful, be very useful, save time. And we get it other ways on bond reports. So, but it's written, handwritten, prone to error. So I think this is an efficient and useful amendment. Thank you very much.
Thank you. Seeing no one else wishing to speak, Delegate Thomas, you have the final word.
I just appreciate the committee's time on this matter. It helps our public defenders and also decrease waste, honestly, on our Commonwealth attorney side, so they're not duplicating records. So really appreciate everyone's time on this, and I hope the bill reports.
Thank you. And before I call for discussion, I just want the correction. It helps all defense attorneys.
What did I'm sorry, Madam Chair.
Yeah.
Move the report with substitute as amended.
Second. Any further discussion? Clerk, please open the roll. Members, cast your vote on HB 1627 report with substitute as amended. Passes by a vote of 6-1. Thank you very much, all the people who have worked so hard on this. Now we have before us keys HB 1630, which is the patron Keys Gamara.
I almost said good morning. Good afternoon, Madam Chair, members of the committee. Before I explain the bill, I believe we have a line amendment.
Yes, these were not officially prepared, but they've been given to council. It looks like on line 20, after the word electronic means, we're adding the phrase or physical copy. And on line 23, after police report, adding related to the case or cases charged.
Are any questions about the amendment as reported?
Move the line amendment.
Moved and seconded. All those in favor say aye.
Aye.
Opposed? Please proceed.
Thank you. Madam Chair, HB 1630 might look familiar, was also presented and passed both the House and the Senate last year. It essentially seeks to provide electronic discovery to improve access to justice, requires all attorneys for the Commonwealth to provide discovery material for all courts to counsel of record for the accused if requested by electronic means as defined in the bill, unless such material is prohibited from being distributed by law or impossible to provide for electronic means. The bill also requires the attorney for the Commonwealth in any district court to provide to counsel of record for the accused, if requested by electronic means, a copy of any police report at least 10 days prior to the date the case is set for trial. This bill is a recommendation of the Virginia Indigent Defense Commission, and I hope that it is the will of this body to report this bill.
Are there any questions of the patron? Yes, please, Delegate Cousins.
Thank you, Madam Chair. I just have a procedural question.
Got you.
So, and council, if you could help with this, that would be great too. But it seems that the language in this bill is pretty identical to language in 2314, which we just incorporated into 1627.
Madam Chair, we didn't incorporate this portion of 2314 into 1627. This portion was basically, I guess, stricken from 2314. So this is a standalone.
Thank you. Delegate Batten?
Thank you, Madam Chair. Question either for council or for the patron. Is it currently required to provide police reports in all courts, general district court and so forth?
Madam Chair, Delegate Batten, under the discovery rules of general district court and juvenile domestic relations court is not required. It is under the discovery rules in circuit court.
So this is a new requirement, Madam Chair? Madam Chair, for council? Would this be a new requirement?
It would put a new requirement on, or what would be available through discovery, yes.
Thank you, Madam Chair.
Thank you. Are there any further questions, Council? Anything else you wish to bring to our attention?
Madam Chair,
I'm sorry, Delegate Williams first, and then Council.
Yes, to the council. Brady versus Maryland requires this, correct? And this would codify what Brady is asking, or what Brady is requiring?
If there's inculpatory or exculpatory evidence in the police report, then yes, it would have to be turned over under Brady. But if the Commonwealth doesn't deem there to be any exculpatory evidence in the report, it would not be required under Rule 7C5 or Rule 815.
Then, now, Council, are there other things that we should be aware of?
Madam Chair, Mr. Hatcher and I are working on, I think, the addition of the word or a physical copy is sort of not working in the language. So I would ask for a couple minutes for us to work through that issue to see if we.
Can I ask?
Yeah.
Madam Chair, if I may ask the patron or the committee, the intent of the bill, the way it's written, is that any discovery material shall be provided by electronic means. By adding the or physical means, just the way that language kind of meshes together doesn't make sense with how the code section itself is written to say you shall be giving this discovery by electronic means. So instead of adding the clause, or physical copies, it might read better to say a new sentence instead that says, however, if electronic means are not available, a physical copy shall be provided to the defense attorney, something along that lines. I think that would read better to the intent that we want it to be electronic means, but if you cannot do it, physical capabilities exceed what the office can do, that the physical copies can then still be given.
Then
we would accept that friendly. Madam Chair, are you directing that question to me?
Do you regard this as a friendly amendment?
I do.
Then Council, continue to refine it. We won't vote on it quite yet until you're absolutely comfortable with the wording. We can do it before we act on the bill itself.
Madam Chair.
Yes, Delegate Williams.
Sort of a question for the council while they're working on this. I think we got into this a little bit last year, where some things could not be turned over. And so I wanted to just remind council about that issue so that it's incorporated when you're thinking about that amendment.
Madam Chair, if I could just ask for clarification of Delegate Williams. I remember that conversation last year, and I think that's where the sentence about being prohibited from being distributed or impossible to provide by electronic means came from. That was not actually in the original bill from last year. That was added during our subcommittee meeting.
Thank you, Delegate Williams. Seeing no other people wishing to address the bill, let us turn to the public. Those in the room who are wishing to speak in favor of, please all stand so I can see how many. We've got one speaker. Please proceed, 2 minutes, and identify yourself and who you represent.
Madam Chair, Tim Coyne, Deputy Director of the Virginia Indigent Defense Commission. And this bill, we thank Delegate Keys-Gamarra for carrying. It is a recommendation of the VIDC. Again, we oversee 29 public defender offices, and there are probably about 1,000 court-appointed counsel that we do certify. This bill is really about just fair, equitable, and timely discovery. Mass majority of our offices already receive discovery in some electronic form, either email with a PDF, a downloadable link, CD, flash drive. There's something called Axon, which is for body-worn camera. Some Commonwealth Attorney's offices even provide links or a file share with that. This can be done and, in fact, is being done throughout the Commonwealth. But there are areas and places where it's not. And what happens, again, as I referenced with criminal records, is public defenders and court-appointed counsel are required to go to the Commonwealth Attorney's office and physically sit and take notes because the Commonwealth either won't provide a copy or won't provide it in electronic form. Incredibly time-consuming, incredibly inefficient, and a waste of resources. And it's actually more taxing on court-appointed attorneys who have to take time out of their schedules and travel, and for what they're getting paid, which is minimal, it's really a disincentive, and we're losing attorneys to do this kind of important, critical work around the Commonwealth. The bill does just really three things. It requires the Commonwealth to provide electronic discovery or physical copy upon request, requires a provision of the police reports in district courts within 10 days. And yes, that is a new provision, but in practicality, it's being done by Commonwealth attorneys around the Commonwealth. They're giving police reports because it's easier than having to redact everything except the defendant's statements at that level. And it's important, the 10-day period is important so that it's timely and it's not being provided on the eve of trial. And lastly, it attempts to define electronic means. Email is sufficient with the PDF, and we would ask the committee's support of the bill.
Thank you. And online we have Dwayne Barron from Justice Forward. Dwayne?
Yeah, good afternoon. Madam Chair, I practice in 5 jurisdictions in the Stanton Public Defender's Office, 3 of which provide electronic discovery this way all the time. It's very efficient. One of which we have to go in the office and sit down and take notes. And I think this bill would allow us to have that across the board. To Tim's point about the burden on a court-appointed counsel, it's particularly difficult for them. Our offices are close to the Commonwealth Attorney's offices. Court-appointed attorneys have a much bigger radius in which they operate in. So going in and spending time in the Commonwealth Attorney's office is a bigger burden for them. And I would ask you to support this bill.
Thank you. Seeing no other people wishing to address the bill, you have the final word, Delegate Keys-Gamarra. Did I not call for those in above? My apologies. Please come forward, speaking in opposition to the bill.
Tracy Quackenbush Martin from the Commonwealth Attorney Services Council. I'm the Commonwealth Attorney in Halifax County. We are speaking in opposition to this bill, not because it doesn't contain noble and laudable efforts, but because statewide funding is not there to support the infrastructure that, in fact, making this work in jurisdictions that do not have locality funding for an electronic database, for electronic means of exchanging discovery, that those things are not in place currently. My jurisdiction and many jurisdictions do exchange as a courtesy, and because it increases efficiency for us, because we had the funding to do that because of our locality, or because, in my case, we were deprived of personnel and had vacancy savings that were approved to use for that means. But impossible is a big standard, and that impossible is not seen anywhere in the code that I'm aware of in terms of a standard of deciding what can be done and what cannot be done. It is simply impracticable many times, even in my office, when we provide electronic discovery, to provide it in every case with every body of and type of discovery that's available. It also means that if I can do it, that the people in deep southwestern Virginia and other less well-funded places would have to be able to do this. And what you're doing, what you would be doing, to echo the words of our governor who vetoed this bill last year, is creating an enormous unfunded mandate for those localities by requiring them to have electronic data, electronic database, electronic means of discovering, exchanging discovery, when that is not currently in place now. Madam Chair and committee, there are many times where it's simply impracticable to exchange these things. When we walk into General District Court, it is often less than 10 days, and we're handing physical copies over. Thank you.
Thank you. Now, Delegate Keys-Gamarra, you have the final word as patron.
Thank you, Madam Chair. I did have an opportunity to speak with the last witness, and as one who does not practice a lot of criminal, but enough to understand that what amount of work it takes to prepare a trial and to exercise your due diligence to represent someone well. I believe from that experience that 10 days is, having that information 10 days ahead of time is reasonable. A shortened time period means that somebody more than likely is perhaps not getting the zealous representation that our ethics rules contemplate. I do understand that there may be some financial burdens, but I would argue that the burdens upon a defendant's ability to get justice are far more costly, and that we need to take the steps necessary to lift that particular burden. And if our administration has concerns, then certainly we can use our purse strings to correct that. But we cannot continue to send messages to the people of the Commonwealth that their access to justice is not worth that cost. So I would ask that this committee report this bill. Thank you.
Thank you. Are there any questions of the committee? Any comments? Motion is in order.
Second.
It's been moved and seconded that HB 1630 be reported as amended, and we did, I think, may I suspend for one moment? Did we have the amendment to incorporate Cherry on this bill 2227? There's a whole other bill. Well, there's a lot of moving parts, and I'm trying to keep them all in the right box here. Okay.
Okay.
We do need to actually adopt the amendment that was discussed. If council would please report it.
You got it. Yeah, Madam Chair, we're going to add a sentence at the end of subsection B that reads, any such material that is impossible to provide by electronic means shall be provided by physical copy unless such material is prohibited from being distributed by law.
Okay. You've heard the amendment.
Second.
Any questions about the amendment? All those in favor say aye. Aye. Opposed? Okay. That amendment has been adopted. Therefore, the bill is before us as amended. Do I hear a motion?
Second.
Any further discussion? Please open the roll. Members, cast your vote. HB 1630 is reported with amendments by a vote of 6-3.
6-1.
Pardon?
6-1.
I'm sorry, where did I get 3 from?
I don't know,
I don't know
Madam
either.
Chair, but
right.
one sounded way
By
better
a
than
vote
3.
of 6-1. Because by electronic means, that is the record rather than my words.
Thank you.
Now, I believe we have 2 bills still on the docket, and with great patience, we have Delegate Leftwich is back before us. Just to explain, his bill was before us at the last committee meeting, but because of a lot of conflicts that had to do with everybody being in and out as far as making budget amendments, there was a misunderstanding that his bill was not being taken up, so we didn't have testimony on the bill. Action was taken to table. Fortunately, whenever you table something, you can bring it back up again. So we are then now have this bill before us.
I have a motion. Do I have
yes,
a vote on the prevailing
motion
side?
is to
have a vote on the prevailing side, which we laid with House Bill 2574 on the table. I'd ask that we reconsider that vote.
Second.
It's been moved and seconded that we take HB 2574 off the table. All those in favor say aye.
Aye.
Opposed? Okay. Now, Delegate Leftwich.
Thank you, Madam Chair, and I appreciate the committee's willingness to entertain this my rerun here in front of the Criminal Subcommittee. So House Bill 2574, again, just to reiterate my comments from last committee meeting, is to add 2 offenses to an existing code section that requires the intake officer of the juvenile court to notify the local superintendent of certain offenses that have been filed within that court. The list of current offenses includes armed robbery, homicide, distribution of drugs. Typically, violent offenses. And so my bill would add 2 additional offenses to that list. The first is carjacking, which is a violent offense. And if you have someone that's been charged with carjacking in the Juvenile and Domestic Relations District Court, that may lead one to conclude that this person could be a danger to other parties. And so the rationale is that we just notify the superintendent of that. And the second offense would be sexual extortion. I would, one reason why this offense is not in the list of offenses is because it's a relatively new offense. It was added, that offense itself was added to the code fairly recently by a bill submitted by former Delegate Bell. And so when this statute was created, that offense doesn't exist. It didn't come to mind to include it. I would say that bill, that offense being notified, the superintendent being notified of that offense is critical given the problems we have in our schools regarding sexting and young women being taken advantage of by a picture that's taken and you threaten to send it around school. If you have a person, I hate to be sexist, but typically it's young males who are doing this, I think the school system should be aware of it to ensure that it doesn't proliferate. So,
thank you.
Thank you.
Are there any questions of the committee or of council? Seeing none, then now we will have public testimony, which we did not have at the prior meeting. Anyone who wishes to speak in favor of HB 2574, if you would please come forward so I know how many speakers I have. Seeing none, anyone wishing to come forward to oppose 2574, please come forward. Seeing only one speaker, 2 speakers, still a maximum of 2 minutes apiece, please. About 2 minutes, yes, apiece.
Thank you, Madam Chairman and members of the board. My name is Brian Kelmar, President and co-founder of Decriminalized Developmental Disabilities. Although this is a good intent, it has unintended consequences. These are children, and oftentimes our people with autism get caught up in inappropriate sexual behaviors. Even though it's great that you report it, this is an alleged allegation that could be dropped, but yet the damage is done. Once you call that superintendent, what superintendent would not expel that child from the school? So now that person's out of the school, and then that allegation becomes either void or downgraded, but now you've already destroyed the child. And this has a negative impact on kids down in their life. I mean, what would happen if one of us was accused of something that later we proved that we were innocent or was downgraded, but our lives would be destroyed? So why are we doing it to children? And especially, unfortunately, our developmental disabilities children get caught up in this, unfortunately, quite a bit. But given corrections that we have in place that work with people to, correct their behavior, we can fix that. But once they're kicked out of school, that's a mark on their lives forever. And they'll have a lot of trouble getting into other schools. And we think the records are sealed. Nothing is confidential these days. Everything comes out one way or the other on Facebook or one of the other media. Thank you. We oppose this bill.
Hi, Madam Chair, members of the committee, Maisie Osteen from the Legal Aid Justice Center, and I'm sharing a message from our youth justice program. And they oppose this bill, that although it's focused on notification, this bill expands suspension and expulsion rights for schools for off-site conduct. Schools get notice of the offense, but not the context with which the offense happened. And that often creates fear and stokes bias. Just a case that we represented, a child who had a developmental disability on, didn't understand the nuances of flirting and consent. And he said something to another student online along the lines of trading naked pictures for homework help. This ended up being referred to juvenile court, and though the case resolved at intake, had it not, it could have been sent to the school, he could have been expelled when it wasn't appropriate in that situation. The bottom line is that the juvenile courts hold detention hearings and detain dangerous kids. Those kids are not included in this. That's already happening. That is their role, the juvenile justice system's role, not the role of the schools. If a judge or the police have determined a child is safe in the community, then with no nexus between the charge and the school, the child should not suffer educational consequences. Thank you.
Thank you. And we have online another individual, Dwayne Barron, who is registered to speak against 2574.
Yeah, thank you, Madam Chair. Those last two speakers said everything much more eloquently than I can say, and so I would just reiterate the Justice for Virginia's opposition to the bill to expansion of these notice requirements.
Thank you. Seeing no one else, Delegate Lefwich, you have the final word on your bill.
Thank you, Madam Chair. So, having been a former member of a school board, it was our policy that unless an incident occurred on school property or under school jurisdiction, no disciplinary action would be taken. And the second thing I would say is that if someone is under a disability, they probably have a special education plan. And unless, and the court cannot, they can do a short-term suspension, but they cannot do a long-term suspension unless they find that the offense is a manifestation of their disability. They have to find that the offense was not a manifestation of their disability in order to do a long-term suspension. So I respectfully submit to the committee that some of the concerns that you've heard this afternoon do not apply. And the intent of the bill is to simply make sure that other students are not subjected, and it's not intended for a disciplinary action against a student in the school system. That's already happening in the judicial system. This is a way, like the other crimes that are already in that list, to ensure that other students aren't somehow inadvertently become a victim themselves.
Thank you. Seeing no one wishing to speak, I'd like to speak to the bill. As the long list is of concern, and how it's used is of concern for sure. And I certainly detected in some of the testimony real concern about the justice system in the way in which they treat neurologically disabled individuals, and I've certainly been working on that across all age ranges. But having said that, I'm also very persuaded by voices that I have heard that have brought to my attention that what this list should be is a list of offenses that may affect the safety of the school. And I don't see carjacking there at all. You can say it's a violent crime, and that's a whole other issue, but it doesn't affect the safety of the school. Having said that, I would personally hope that I can entertain a motion that would strip that out of the bill but still leave the sexual extortion, because with the internet and chat rooms and all of this activity, this definitely is activity that if law enforcement feels that they have the basis to charge on it, is an individual whose activity I want the school system to be aware of, lest it affect other of my students. So that would be my statement. We act on the basis of motion.
Madam Chair, I just want to also speak to not the motion, but to the bill, if I can. And I guess my concern is, I heard Delegate Lefwich talk about the discretion that at least the school board he was affiliated with would look carefully at the circumstances of the crime and the circumstances of the individual and make some determination whether or not you pursue any suspensions or expulsions. My concern is that there's nothing in the statute that would require that kind of distinction throughout school districts. And my concern is that passage of this, even though the existing code is already there, adding to that is not going to make things any better. And the examples that were given about sexual extortion, I mean, that concerns me, that you might see more people get into this, wrapped up into this situation than others. So I'm concerned about the bill And that would be, I feel good about what Patron said about the school district he represented, but I don't think all do that. And that concerns me.
Mr. Overchair, if I may make sure I understand what you're saying. So we have a list of, 13, 14, 15. Your concern is only about adding extortion to the list or about the underlying statute and what's done with the entire list?
Well, I mean, the bill is at hand, and so the bill is what concerns me. But I'm certainly concerned with the statute.
Thank you. I have a request to speak first from Delaney.
Thank you, Madam Chair. I mean, sorry. I hear all of the concerns and, understand that, we need to do our due diligence in this committee to avoid the unintended consequences that were laid out and the Uber Chair's, concerns about how justice is kind of equitably, or maybe not justice, but, discipline and or justice is equitably delivered across the Commonwealth. But I do want to take a moment just to comment on kind of the counter to, the balance that we need to strike when some of these explicit images that minors share of their classmates, we talked about kind of the lasting effect of a suspension, but having worked with, population of young people who often fall victim to sextortion and the sharing of non-consensual intimate images, the impact that it has on their lives is permanent. And having those images out there forever shared among classmates has an absolutely devastating effect. The rates of suicide among particularly teenage boys and sextortion scams is heartbreaking. And I think that, we do need to be aware as we kind of navigate how we want to go about addressing this issue to recognize that our justice system is not yet equipped to really deal with these incidents that are sometimes not even really viewed as crimes. And that are not always addressed with the, I think, disciplinary vigor that many of us as parents, I think, would hope if your child were to be victim of this type of exploitation. And so just kind of want to note for the record, I guess, as the committee deliberates on striking the balance here and recognizing that there are many unintended consequences that we need to navigate to ensure that, this is an equitable solution. But do just want to add that consideration that, when a young person has these images shared, whether they be, obtained, consensually and then distributed non-consensually, or, the prevalence of the proliferation of deepfake, AI-generated images is really becoming, a crisis across this country. And I hope, if not at this moment, will be something that this committee can work with to find some solutions for. Thank you, Madam Chair.
And I also have the Delegate Coulson.
Yes, Chair Watts. I guess I certainly am not comfortable with carjacking.
If you could put your microphone on.
Chair Watts, certainly, if I can speak to the patron, certainly or ask a question. I'm uncomfortable with carjacking. I don't see a nexus between carjacking and why that would relate to school safety. And then I'm just trying to rack my brain here. I also served on a school board, and I was a teacher as well, and I'm trying to understand what exactly you're trying to accomplish with the sexual extortion. A victim would tell the school, and if the child was going through the criminal justice system, he would be given a punishment appropriate for that crime, and he would be serving a sentence, or he'd be on probation. He'd have all those things. So I'm not. Does a patron know? Maybe your school board did it different. Did you have situations where this happened and nobody knew, and then later? So, where did that come from?
So, well, this did not originate from my school board or my city. So, I just used mine as an example of how we handled these types of notifications. But what I would say is that, from my experience, not the school board, but the superintendent would notify staff that said, hey, look, we have an offense that's been filed against this student. Let's keep eyes on the situation. Let's monitor it. Not only that person, but perhaps the victim, to make sure that there's no other inappropriate interaction. And so I don't know that just a statement by a student, especially if it's something that happens on grounds, and the school system is aware of it, they're going to take disciplinary action. But if this is something that happens at a beach or in a mall, and the school grounds are not involved, then you can't go to the school system and say, hey, this student extorted me sexually through pictures. Our system would say, well, that's not on school grounds. We have no jurisdiction over that. So they file a petition with the juvenile court. A magistrate determines whether charges are warranted. They file the charges, and then the intake officer would then notify the school board, hey, you have students in your system that are engaged in this event. And, I guess each school board would then address that in the way that their policies dictate. And in my school system, it would be, let's keep an eye on it, make sure there's no interaction, nothing else happens, or in the same class. Let's separate the class. Let's take this young lady and put her in a different class, or put this young man in a different class, so that we don't have another problem with these two students, or maybe we need to make sure that this is not a situation that is happening to more than just one.
Chair Watts, if I can ask a follow-up. I guess I want to register my discomfort with expanding the criminal justice system into our schools. A lot of while being sensitive to the fact that this is terrible and, it should not be happening, but we're not talking about creating a crime around this. That already exists. There is a criminal code that could be utilized to go after these children. What we're talking about is allowing an assumption about that to go into the school system, when I will just say, as you alluded to, there's many avenues for that information already to get to the school. Certainly if the victim's in the school, actually, I would argue should be up to the victim whether they want people in the school to know. And they should be able to tell the school, and they usually do. And sometimes they don't, because they don't want to have that out there. So it's not necessarily compelling to me to hear that somehow if we grant a school system, not unfettered, but increasingly broad access to what's going on in a criminal court, it's going to somehow change outcomes or behavior, or something doesn't feel right to me about that. So I guess I want to say that. And I also want to say, just because it's worth pointing out, is that all of this is only, it's only in public schools that this would apply. And I don't know, I just don't find it compelling to say that something that happens at a beach should be right to your teacher's ear. And so I want to register that.
Delegate Colson's off. Okay, so we have the situation that we are in now. One, I needed to have had a recorded vote on the motion to take off the table. Clerk, if you would please open the roll so that we can have a recorded vote on the motion to take off the table. Okay, so the motion to remove from the table passes by a vote of 8-0. That done, the committee operates by motion. Delegate Delaney.
Madam Chair, you had mentioned, and I don't know the pleasure of the committee on this issue. I know there are a lot of concerns, but you had mentioned the possibility of offering an amendment that struck the carjacking language and narrowed the scope specifically to the sextortion type crimes. I don't know if the patron would be agreeable to narrowing the scope of the bill.
I would view that as a friendly amendment.
Clerk, if you would, and you so move?
So move.
Second? Second. So it's been moved and seconded. If you would report, then we are striking which line in the bill?
Madam Chair, I'm not positive of the line number at the moment, but it would, line 67, it looks 167. It doesn't matter. We're just moving instead of line 15 saying carjacking, line number 15 saying carjacking, number 15 would then just say sexual extortion.
You've heard the motion. All those in favor of that amendment, please, do I have, I keep on forgetting. Recorded vote. Recorded vote. Voice vote. Voice vote. All those in favor of the amendment to strike carjacking, please say aye.
Aye.
Opposed? Okay, so the bill before us then deals with sexual extortion, adding it to the list of offenses to be reported. Now the committee works on motion.
Move the report.
Second.
Madam Chair, can I speak to the motion?
Yes, of course. Now
sometimes-
speaking to the motion, Coulson, did you want your name dropped? Okay, please proceed, Delegate Hope.
Sometimes we do this in the courts committee, and maybe I'm in the minority. I just want to take a temperature here. I'm uncomfortable with even the bill as it is, but I do think the statute might need to be looked at. I think people have raised some concerns about how it's being implemented. One of the things that we could do is I could write a letter to the Crime Commission to take a look at the entire statute and to see how it's working and what the results have been over time. I'd like to hear how other school districts are dealing with these notifications and what actions that they're taking. Maybe these are the right, and come back with a bill next year to look at, are these the correct offenses that they should be notified? We talk about the nexus to education and the crime and education itself. Are those the right ones? Should there be others? And maybe come back in the future with a bill that maybe cleans up the code. And so I want to put that on the table. If people are feeling uncomfortable, as Uber chair, I would be willing to send a letter to the Crime Commission, probably the best place to put it, I think, to ask that they take a look at this statute, evaluate how it's working, and to see how school districts are dealing with the notifications and what the outcomes are. How many suspensions and expulsions are we seeing as a result of these notifications and convictions?
I think it's appropriate for me to respond as chair. I've been at this a long time, but I've been in the minority most of that time, so I haven't been chairing. So anytime that, in my response, I think that's an excellent suggestion, but not in lieu of. I see no harm at all. In fact, appropriate for the Crime Commission to be looking at sexual extortion because it involves student-to-student behavior, and their total look of whether this statute is properly in the code, period, and if it's properly in the code, then how should the guidance go out about how it's used to school board decisions, and then what should be in that? What is appropriately should be of concern to the school to protect students and so that parents are aware of these issues? All of those things are important issues, but again, speaking for how I will be voting, I believe that the sexual extortion is part of that whole consideration, especially when I look at some of the other, what I'll call older offenses that have always been on the list that have tended to be just because they're regarded as a violent offense. So whether that was appropriate or not to say as chair, I did. Are there other people who wish to speak before we cast the vote on the bill? If not, clerk, please open the roll on HB 2574 to report with amendments. Members, cast your vote. The bill is reported by a vote of 5-3.
Thank you, Madam Chair. I appreciate the committee's time in deliberating this bill.
And I think when I report it, we'll discuss whether I make the request on behalf of the subcommittee for such a letter from the chair to the Crime Commission. Now, Delegate Williams, aren't you glad that you're on this committee and you get to go last?
Yes. Thank you.
Yes. I was wondering who was going to do that.
Madam Chair, members of the committee, thank you for hearing me today. This is Bill, let's see, I don't have the number in front of me, 2252, and I'm going to read the summary.
Actually, Delegate Williams, if you could bring it up a little bit more, the microphone should be closer to your mouth. Thank you. I'm sorry if that's a problem
okay.
on your vocal.
I like to find it. I like to find out about this. This is great. HB 2252, decreasing probation period criteria for mandatory reduction, establishes criteria for which a defendant's supervised probation period shall be reduced, including completing
qualifying educational activities, maintaining variable employment, complying with or completing any state-certified or state-approved mental health or substance abuse treatment program, securing and maintaining qualifying health insurance or a qualifying health care plan, and obtaining housing in established residence. This bill provides that a court may decrease a defendant's probation period if warranted by the defendant's conduct in those particular criteria and in the interest of justice, and may do so without a hearing. I wanted to pull up Governor Youngkin's Stand Tall, Stay Strong, Succeed Together initiative, to improve reentry success and prevent recidivism. This was released on October 15th of 2024, and some of the quotes here in it are duplicative of what we're trying to focus on. Every single returning Virginian has the opportunity to be a testimonial of hope or a recidivism statistic. Today, we unveiled the Stand Strong, Stay Strong, Succeed Together initiative. Let's see, it formalizes the work we've done, leading to over 3,000 more returning Virginians having gained employment and over 7,000 more having gained health insurance. Our approach is proactive, measuring the achievement of key metrics for success and strategically using state resources through cross-agency partnerships. I'll go on and say, First Lady Suzanne Youngkin said, our focus must be on supporting the Commonwealth's most vulnerable by expanding assessments, improving treatment programs, and fostering strong partnerships. We are dedicated to providing the necessary resources for successful reintegration and healthier futures. This is from Attorney General Jason Miyares. Employment for returning citizens is more than just a second chance. It's a cornerstone of public safety and community well-being. We must continue to improve the reentry process because effective reentry is not just a matter of retention. It's an essential in keeping Virginia safe and strong. If you go to the executive order number 36 from the governor, it identifies 6 different positive factors that facilitate a successful reentry for returning citizens. This includes gainful employment, stable housing, health care insurance coverage, appropriate supervision levels, necessary mental health treatment, necessary substance abuse treatment. If you were paying attention earlier, that sounded a lot like the summary that I read. And so what we would do today is ask that you report this bill as written so that we can continue to incentivize good behavior, incentivize getting credits towards your schooling, incentivize getting employment, and incentivize people to not reoffend because they're in a position where they don't have anything to lose. Losing housing, losing your jobs, losing your friends and family around you because of these probation violations and things like that, it doesn't help. And so what this would do would increase those incentives. And I know there's some concerns about the victims, but oftentimes the victims don't play much of a role in probation. They usually play more of an active role in the sentencing and the parole bills that you see, unfortunately. But this doesn't address that, and that's usually because of not being part of the process, but also not trying to re-traumatize every single victim that has to deal with these unfortunate circumstances. So that's the bill. I'm glad to answer any questions you might have.
Thank you, Delegate Williams. Quite frankly, your presentation of the bill took me a little bit by surprise, because what I was aware of in reviewing the bill last night was that this is essentially identical to the bill that Delegate Coulson had last year that was vetoed by the governor.
Surprise.
So I was a little taken back by your testimony. How is this bill different? You're indicating that you thought the governor would support it. Perhaps Delegate Coulson has any comments about.
Maybe it's just a different
I know
patron.
you supported Delegate Coulson's bill last year.
I did.
Congratulations, yes.
Yeah, so maybe it's just a different patron, different year. This is a 2024 initiative that wasn't in place last year. I mean, I'm not quite sure what can speak for the administration on that particular thing.
I had on the list Delegate Batten. Oh, then I see Delegate Coulson, okay. Yielding to you, Delegate Coulson.
It's late, guys. I was just going to, Chair Watts, if I could speak to the patron. I was going to thank the patron for carrying it. It is very similar to the bill, and he's right. There's subsequent to the session, the governor rolled out his standards. And I do think this still aligns to that spirit of rehabilitation and rewarding and incentivizing good behavior. And I believe the patron supported my bill last year, so maybe it's just better looking, so it will go through this time. I don't know.
Ayes and nays.
Delegate Batten.
Thank you, Madam Chair. A couple questions, if you will, for the patron. So I believe I heard you say that there's no hearing required. This would be automatic. Madam Chair, can the patron acknowledge that that's correct or not?
That's correct. Yes, this would be an automatic hearing or this could be done by the judge without a hearing.
Thank you, Madam Chair, if you don't mind. Just a second question. I noticed that one of the requirements that could be fulfilled would be employment, I believe, of 30 hours per week. And my question for the patron or for council is, if the individual loses their job through no fault of their own, say the business folds, unfortunately, does this individual then start back at square one?
Council?
Madam Chair, Delegate Batten, I think the bill breaks it up into periods as to when you get the credits. So I don't think you'd go back to square one, but I think if you lose your job, even if there's no thought of your own, there would be, you would lose whatever's in that 6-month period because you wouldn't be gainfully employed the entire time through that 6-month period. But if you had already had a year of good employment, you would get the credit for those two ahead of time.
Thank you. And one final question, if you will. Question for the patron also is, I would think that this would be a pretty substantial workload for probation and parole officers. I don't know if there's anyone here who could speak to that. Obviously, there would be substantial data collection required in order to fulfill this. And I'm not overly familiar with the structure of what that would look like. So I don't know if there's anyone, if the patron himself can speak to that, if there would be someone here in the room. Thank you, Madam Chair.
I believe the Department of Corrections is here to speak to in opposition.
Representative from the Department of Corrections.
Good afternoon, Madam Chair, members of the committee. Marcus Elam, Corrections Operations Administrator for the Department of Corrections. To answer the member's question, the bill does not alleviate current practices for the Department of Corrections and probation officers. Currently, our supervision practices were certified through the American Correctional Association, and that's where we get our certifications on how we meet standards for supervision, which includes our assessments, which includes our normal processes, including how we request through the court to release folks from supervision early. This bill does not alleviate us of those requirements, so the requirements in this bill would be in addition to what we currently do, so it would increase our workload.
Thank you very much. Are there any other questions of the committee? Seeing none, any other further comment from council? Is there anyone here to speak for the bill? And seeing, if you could put your comments within a total of 6 minutes, please.
Yes, ma'am. Good evening, Madam Chair, members of the committee. Tim Parrish with Americans for Prosperity, and we rise in support of the bill. We think that it's a great bill and really appreciate the patron for pushing it. As you've already stated, this is in alignment with the governor's new standard that he put out, and this is a bill that passed, I think, unanimously in this body, and it passed with bipartisan support in the Senate chamber last session. So we do support the bill and would encourage you to do the same. Thank you.
Good afternoon, Madam Chair, members of the committee. Sean Winetto speaking on behalf of Reform Alliance. Madam Chair, if I may address a couple things that have questions that have come up. As far as how this differs from last year's bill from Delegate Carlson's bill last year outlined 3 success factors and incentive opportunities. That is different this year in picking up 6 opportunities for success, or 6 earning opportunities, and those align with the governor's success factors that are data driven. So as far as this data collection, if I may address Madam Chair, Delegate Batten, the collection of this data is already being collected in line with the governor's executive order. It's already data that is being collected by the Department of Corrections. There is going to be some work that comes with enacting or implementing this. However, that is data that is already being collected. So on behalf of Reform Alliance, we do support this bill and ask the committee to report it out. Thank you.
Madam Chair, thank you for hearing me. My name is Mike Berryman, and on behalf of No Left Turn, we support this bill. But on a personal note, for someone who is under supervised probation, I think it would be a great idea to have incentives to help remove me from said probation and encourage others to do likewise. Thank you.
Madam Chair, Committee, Fatima Mowahed with the Humanization Project. This bill creates positive reinforcement, rewarding positive behaviors such as education, employment, and others that were listed by the delegate, and it incentivizes continued rehabilitation and reduces the likelihood of reoffending. Ultimately, this is encouragement for returning citizens to continue to be productive parts of society, which is ultimately the goal. It helps reduce disparities as well. We hope it's the will of the body to report this bill. Thank you.
Thank you. Is there anyone here to speak against HB 2252? Seeing no one come forward, we have no one online. Delegate Williams, you have the final word on your bill before we take action.
Actually, I think there was some concern about how fast this would be implemented, so I'd be open to an enactment clause.
Yeah, Madam Chair, I had my light on. I don't know the appropriate time.
So at this, yeah. Then you still have your chance, then we're still taking action. No, we're taking action now. So that's your final word. Mm-hmm. Anything else before we take action, which will include your suggested amendment?
No, thank you. Thank you, guys.
Okay. Delegate Carlson, do you wish to be recognized? Delegate Delaney.
Madam Chair, yes, I'm just taking a note the concerns around implementation. I know that many of these policies are already part of an executive order that's working and underway. I know that there are other provisions that states like Florida have implemented that the department may need time to kind of look at how other states have successfully implemented some of the policies, and if a delayed enactment clause of a year would be agreeable to help get this done right, I would offer that as an amendment.
I see that as friendly.
Okay, it's been moved and seconded that there be a delayed enactment clause, 1 year delayed enactment clause. Any discussion on that motion? All those in favor of the amendment to add a delayed enactment clause say, it's a recorded vote, right? I'm going to get this right? Yeah.
No, to amend this.
But we had no. Never mind. So all those in favor say aye.
Aye.
Opposed? Okay, the bill has been amended with a delayed enactment clause. Any further action on the bill? Comments on the bill? We operate by motion.
Move the report.
Second.
It's been moved and seconded that we report HB 2252 as amended. Council.
Just to make sure that we have this amendment correct, this is a year delayed effective date, so that would mean that the bill would go into effect July 1, 2026. Is that the intent of the subcommittee?
Yes, Madam Chair.
1 year.
Thank you.
Then with that clarification on the amendment, clerk, please open the roll. Members, cast your vote. Okay, the HB 2252 has been reported with amendments, by a vote of 7-1. Having seen no other business before the subcommittee, we stand adjourned.